All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead, draw near, give attention, we shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good afternoon. Welcome to the Florida Supreme Court and the 2016 final round of the Florida High School Moot Court competition. We are pleased to have teams from all 5 districts Court of Appeals in Tallahassee today, and we welcome the students as well as their teachers, coaches, parents, and families. Just so we know who we have, the teachers. Could you stand, please? And we have parents here? If you would stand. Terrific. Any other members of families? Okay. And we are encouraged to see such interest in learning about the state courts and the appellate process. And we appreciate you taking the time to come to Tallahassee to see this. And I thank you to all of you, the students who wrote and submitted briefs this year, and to the teachers and attorney coaches and judges that assisted throughout this process in each of the 5 regions. Following oral arguments today, we will recess and go back into our conference room to basically make a decision in your case. And then we will not announce our decision, obviously, but we will come back on the bench again, and then we will provide you with some of our feedback on your performance. And after that, we will pose for photographs with you and the other teams as well. And my understanding is that later on today, you will have a reception over at the Edison restaurant at Cascades Park, which is, if you haven't been there, it's beautiful. And at that time, the winners will be announced. Okay? Having said that, our case today is Logan Bartram versus State of Florida. Are both teams ready to proceed? Yes, sir. So let's begin.
Mr. Chief Justice, and may it please the court. My name is Evan Barkey, and this is my co-counsel, Charles Suarez. Together, we represent the petitioner in this case, Logan Bartram. I will argue the first issue, whether recklessness is sufficient to sustain a conviction under Florida Statute 784.048, and my co-counsel will argue whether Florida Statute 784.049 is constitutional. The First Amendment permits restrictions on the freedom of speech for a few well-defined, narrowly limited classes of communication clearly supported by history and tradition, including what the Supreme Court announced in Watts versus United States as true threats. The lower court adopted a reasonable speaker standard to determine whether a statement is a true threat. There are 3 reasons why an objective standard does not comport with the First Amendment and why a subjective test is preferable. First, an objective test does not adhere to the Supreme Court's interpretation of true threats. Second, a subjective test is in line with other First Amendment exceptions. And third, an objective test impermissibly chills speech. In Watts versus United States, the Supreme Court held that in order to criminalize pure speech, a government must first prove that the speech was a true threat. The Supreme Court in Virginia versus Black held that a true threat must mean to communicate a serious expression of an intent to commit unlawful violence, and that it must be made with the intent to place the victim in fear of bodily harm or death.
When you say that an objective test is not the test that should be used, why wouldn't it? It seems to me that what we're looking at is whether or not a reasonable person Isn't that the objective test standard? Whether or not a reasonable person would believe that this was in fact a threat.
That's correct, Justice Quince. However,
So why is not that appropriate?
because the Supreme Court in Virginia v. Black adopted a subjective intent test and held that a true threat must be made with the intent to place the victim in fear of bodily harm or injury.
But is the 11th Circuit decision in U.S. versus Martinez, are you familiar with that case?
Yes, Your Honor.
Didn't that explain that whatever was said previously, that they were applying an objective test as opposed to a subjective test? Or am I misreading that case?
No, you're correct, Justice Pariente. The 11th Circuit has held and has adopted a reasonable listener test. However, that case has not been reviewed by the Supreme Court, and we would argue that a decision by the Supreme Court is more persuasive than one by a Circuit Court of Appeal. Furthermore, the Supreme Court in Virginia v. Black rejected a intent to carry out test, and thus the court left open adopted a subjective intent test.
But let's take, we don't have in our record the exact words of the lyrics, which I'm sure must have hindered all of you that are arguing. But if we took something which is some of those, I'm going to kill you, and we know objectively if you're a reasonable person, you're going to, it depends on the medium, but that is objectively a threat. You could, I guess, give a defense to say, he knew under the circumstances we were kidding around. I was just kidding. It was a joke. We had just watched a TV show, and I was pretending to be somebody on the TV show. So, but why there are certain words that are going to be objectively threatening. So that's why I'm having trouble understanding why the subjective intent is the necessary predicate for the conviction.
I have 2 points with regards to that, Justice Pariente. And the first is with regards to the lack of any specific statements that were made in this case. We argue that the government had the opportunity to provide those statements, and the lack of those statements hurts this court in its ability to determine whether or not there was a specific intent. Furthermore, your example gave one of the dangers of an objective test, which is that it leaves open the criminality of somebody's statements to a reasonable person. And a person who made a statement in jest or jokingly could be could be convicted, in this case, for a third-degree felony.
But it seems to me that even though we don't have the exact words in the record, what we do have is that he was interested in music and writing music even before the breakup with the girlfriend. But after that breakup, the whole tone and tenor of the lyrics of his music changed, and he used the actual image of the victim with that changed tenor. So can't we look at that to see the intent of your client?
Certainly, Justice Quince, that would be one of the many factors that a court could look to whether to determine somebody had a subjective intent to inflict emotional distress to that person. However,
what was the point then of using her image with those changed lyrics if it wasn't to somehow get to her and let her know that how unhappy he was about the breakup, obviously?
Justice Quince, we would argue that because somebody changes their music style does not reflect any subjective intent to place another person in fear of bodily harm or injury.
But these were not just photos, were they?
No, these were photos, and they were posted along with lyrics.
Right, but they were not just innocent photos. These were, or could be reasonably construed to be, objectionable photos. And why could that not be considered in conjunction with the actual words utilized in coming to an interpretation of whether there was sufficient intent?
Certainly, Justice Lewis, that could be one of the factors to look to, and I'll leave to the objectionable nature of those photos to my co-counsel.
Well, but I mean, I don't know how you can separate the two in making the argument as to one's intent if you just pretend that the photos don't exist.
Justice Lewis, the first argument that we are making is that a subjective intent is required, and that this court should reverse the decision of the Sixth District Court of Appeal on those grounds. The second question we would ask this court to answer
Well,
is
how would you describe subjective intent, then? What would the state have to prove here to sustain a conviction?
The jury would be instructed that in order to convict the defendant, the prosecution had to show beyond a reasonable doubt that the defendant in this case made these statements with the intent to place the victim in fear of bodily harm or injury.
And how do you prove intent? Don't you prove intent by the circumstances of the case? And it seems to me the circumstances of the case demonstrate that once that breakup took place, that he started down a different path with his music and using those objectionable photographs that Justice Lewis was referring to.
Certainly, Justice Quince. In this case, any circumstantial evidence, just in any specific intent crime, such as first-degree murder or assault, circumstantial evidence would be the means that the prosecution would use to prove a subjective intent.
Let me be more precise about what that evidence exactly is. When you bring up the photographs, at the viewing of the photographs, do you also hear the music that was done by this particular defendant?
On page 21 to 22 of the record, Justice Polston, it only reflects that the lyrics were posted, and then along with those lyrics, the picture was posted on the faceplace page.
Would it make a difference as to whether or not the music was posted separately from the photographs, or whether they were done together?
Well, record 21 to 22 actually reflects that the picture was posted inadvertently with a sort of a bulk upload of photographs in this case, and we'd argue that the picture...
How does it demonstrate that it was inadvertent?
Your Honor, at the trial court, the defendant testified that he merely selected many photos to upload to his faceplace and may have inadvertently included that photo as among one of them. And I'd like to return to whether or not a subjective intent should be used. In Brandenburg v. Ohio, the Supreme Court found that under the incitement doctrine, to prove that somebody made a statement to incite requires a subjective intent. And it would be strange that such a related doctrine, one that is often muddled in the realm of internet communications, would require a subjective intent, and a objective intent would be used for true threats. Furthermore, an objective test does not properly balance. I apologize, Justice Quince.
So in your argument is that we don't look at all to how the victim actually interpreted what was done. We only look at whatever evidence there was about your client's intent.
Mr. Chief Justice, I see that my time has expired. May I briefly answer Justice Quince's question and then conclude?
Okay.
Certainly, Justice Quince. Whether or not the victim feels that as a threat goes into the statutory requirements for this conviction. The credible threat, the definition of credible threat under the statute requires that the victim perceive the threat as threatening, and it would not factor into the constitutional question of whether or not the statement is a true threat. For those reasons, we ask that the Sixth District Court of Appeal be reversed.
Chief Justice LaVarga, and may it please the Court. My name is Charles Suarez, and I will argue the second issue, whether Florida Statute 784.049 violates the First Amendment of the United States Constitution and Article 1, Section 4 of the Florida Constitution. This statute is unconstitutional on 3 grounds. The material covered today is not obscene, and as a result, it should be afforded First Amendment protections. 2, this statute would not survive a strict scrutiny review that would be required of it, given that it's a content-based restriction on the freedom of speech. And 3, this statute would not even survive a facial challenge, given the ambiguity of some of the terms defined in the statute.
Let me make sure we're talking about the sexual cyber stalking.
Yes, we are talking about the photos that were posted.
I understand that you're making a First Amendment argument, but doesn't a person who has been in a consensual relationship and had photographs taken with the idea they'd be private, isn't there also a right of privacy inherent in the sexual cyber stalking, or are we only looking at the First Amendment? In other words, doesn't the right of privacy balance, or shouldn't that be taken into consideration?
Absolutely, Your Honor. And when determining a compelling state interest under the two-pronged strict scrutiny test, the right to privacy for those who have been emotionally distressed by such photos is definitely to be considered and weighed against first protection rights. However, firstly, we must address whether or not these photos were obscene. Obscenity, if it is found to be obscene, will not be protected by First Amendment rights as found in Roth v. United States. And the most recent obscenity test we have today is a Miller v. California three-pronged test founded in
Well, so you're saying there's no privacy interest that an individual has to protect against depictions of that person's body and that person engaging in sexual acts unless the separate standard of obscenity is met?
No, Your Honor. The interest to protect one's body is always relevant. However, this content, this speech, is only afforded First Amendment protections if it is found to not be obscene. As a result, in order to defend the First Amendment rights of the petitioner, we must comport that these photos were not obscene.
But I don't buy that, because I think that otherwise, and we see lots of examples, unfortunately, cases well after Miller versus California, when the internet has changed the whole nature of communication, where it used to be somebody might sell a book or put on a movie purely for obscenity, pornography. But now we're talking about, as Justice Kennedy was saying, individuals' personal photos. And again, the argument you're making, and maybe it's the only argument that can be made here, is that unless the photograph is obscene, that a person is at liberty to post that photograph wherever they want to.
It is a valid point, Justin Periente, but obscenity is one of the very few unprotected classes of speech we have in the United States. It is alongside other forms of speech such as incitement.
Well, let me answer it this way. Okay, it's a photograph of her naked top, correct?
Yes, Your Honor. Okay,
it was done when they were boyfriend and girlfriend.
Yes, Your Honor.
Did this defendant then have the right to take that photograph, and she was interested in applying to college, and just post it wherever and whenever he wanted to because it wasn't obscene?
No, Your Honor. However, we are trying to proffer to the court today that the material itself is not obscene, and thus the First Amendment question that you are proffering today can be raised afterwards.
I still don't understand that argument. It seems to me that you've got to balance both of these, and her right to privacy is just as important as his free speech right.
Yes, Your Honor, and per the strict scrutiny test, applying a strict scrutiny review, it must be determined that the compelling state interest requires a justification far stronger than a mere speculation about serious harms. And in today's case, the
why would it be a mere speculation? I mean, she says clearly in the record that she was very upset about it, that she is applying to colleges, and we know that colleges and businesses and all kinds of people go on the internet and see what has been posted about you, what kind of pictures have been posted of you on the internet. And so it seems to me that harm is there.
Yes, Your Honor. However, petitioner fears that with a statute as broad and as ambiguous as this one, constitutionally protected speech could be caught in the net that is cast by this legislation.
Okay, now let's talk about that. It's an interesting argument between, are you making, this is 748.049?
Yes, Your Honor.
Okay. There's as-applied challenges and there's facial challenges.
Yes.
Are you making an argument that there has to be, that this is a facial challenge to the statute because it is involving the First Amendment?
Yes, Your Honor.
And that we can't look at whether in a given situation, I mean, the legislature finds that a person depicted in a sexually explicit image has a reasonable expectation of privacy. And I know this is a difficult issue about where, because it's framed as a First Amendment issue, but how that statute seems to be protecting individuals' privacy. And what you're saying, I'm hearing, is that it can do that, but only if the sexually explicit images are obscene?
No, of course not, Your Honor.
Then explain that.
Your Honor, if these photos were obscene, no law would be required to protect it. It would simply not be protected by First Amendment protections. However, it is found to not be obscene, then the statute would allow to be, the First Amendment rights would apply, and the statute would have to contend with a constitutional challenge on First Amendment viability.
So how would you write the statute for it to avoid the First Amendment argument? Have you thought about that?
Yes, Your Honor. Petitioner's two key issues with the statute as written today is that it does not define the term publish nor the term legitimate purpose. In California, a very similar code has been established, California Penal Code 647. However, the California legislature saw it prudent to write in specific exceptions to the statute. For example, if the photos were posted in the process of a subpoena, or if they were posted for the purpose of catching a criminal activity, then they would be valid exceptions. However, today, this statute does not define what legitimate truly means. And
what in the world of photos does it mean to publish if it's not to disseminate on a computer telephone pictures of a young woman undressed? That's not publishing it?
Yes, Your Honor, that would be publishing it. However, it does not determine whether this statute would actually prohibit the selling or distribution to friends of such photos. And as a result, it is ambiguous as to what it actually...
Well, if you give it to someone, you've published it also, haven't you?
No, Your Honor. This statute says that it's only published if it's posted to an internet website, sending your friend an image from your phone.
If he sent it to his friend on his phone, or if he downloaded it to a computer and sent it to his friend, that would still be publishing it, wouldn't it?
Not under the statute, Your Honor.
But this is on like a Facebook type thing as I read it. And this, for anyone in the world, like I guess you couldn't use in this case the word Facebook. But as I read the problem, that's what occurred. Are we wrong in assuming that?
Yes, Your Honor. These photos were posted to FacePlace.
But I mean, that's not accessible by anyone who has a FacePlace account?
Yes, Your Honor. We are not contending that posting these photos to FacePlace would not violate the statute. It does. We are contending that because of the ambiguity of the terms in the statute, it would have...
Well, you said there's a problem with publish.
There's a problem with both, Your Honor, both the word publish and the word legitimate.
Well... But what's your argument that this was legitimate? Because you're arguing that, well, in some cases that you might have some cases where it would be unclear whether it was legitimate or not legitimate. But what's any argument that there's a legitimate purpose for this?
Chief Justice, I see that I've run out of time. May I answer Justice Kennedy's question?
Absolutely. I had the same question, but go ahead.
You can go ahead and answer both questions.
Justice Kennedy, today petitioner concedes that the defendant was properly convicted under the statute. However, our concerns is that this statute would convict our defendant, alike with the foster child who records his foster parent sexually abusing him and posting it on the internet, just like it would prosecute a divorcee trying to capture proof of her husband's infidelity. Because the word legitimate is not properly defined and not properly constrained within a formal legal bounds, the statute can be overbroad as interpreted. For these reasons, we request that this court reverse the decision of the 6th District Court of Appeal and find the statute unconstitutional.
Thank you.
Good afternoon, Chief Justice Labarga, Honorable Justices, may it please the Court. My name is Connor Malusnik, my co-counsel is Jasmine DeValle, and today we will represent the respondents in this case, the state of Florida. I will argue the first issue of whether recklessness with a lack of subjective intent is sufficient to sustain the petitioner's conviction, and my partner will argue whether the Florida statute 784.049 violates the right to freedom of speech. Recklessness with a lack of intent is sufficient to sustain a conviction for 3 reasons. First, the petitioner's communication is not constitutionally protected under the True Threats Doctrine. Second, requiring subjective intent of the speaker to threaten the victim in harassment cases is detrimental to the process of law and security. And lastly, the Florida statute 784.048 does not require subjective intent.
But doesn't the statute require that a person willfully, maliciously commits the conduct? So outside of whether it's a threat or not, when the trial judge instructed the jury on a lesser standard, doesn't it depart from the actual language of the statute? And I guess that's a little different than whether it's subjective or intent or objective, but it requires that they willfully or maliciously do it.
Justice Parienta, you're exactly right in saying that there is a distinction between the true threats and the statute. And regarding those words in the statutes, I would like to turn your attention to the Florida statute 847.012, which states that these words that are included in this statute, like willfully and knowingly, actually hold a relatively small burden. That statute, 847.012, defines knowingly not as an intent to harass, but instead only having the general knowledge of.
Well, it doesn't use, I mean, I don't know, we have cases, it actually says willfully and maliciously, which may or may not be different than knowingly, but you would agree maliciously has a specific intent, not a objective intent.
Justice Parienta, I would definitely agree that there is an intent in the word malicious, but it is not...
they don't use knowingly, though. They use willfully and maliciously.
Those words, we would argue, suggest a recklessness intent. I would like to turn your attention...
Why wouldn't the legislature... I know you... But why wouldn't... You're the state here, and this is the toughest, maybe the toughest question. Why would the legislature, who writes the statute, who defines the criminal law, put in reckless if that was going to be the intent standard?
Justice Parienta, I know it is perhaps confusing, but I think the history of the legislature is clear that a lesser standard is what was recommended. And this is especially so considering that in 2012, the legislature amended that statute to take the word intent out. So it does seem that they are suggesting a reckless intent. And I would like to...
Wouldn't we, if we did that, as you're suggesting, wouldn't we be accused of legislating from the bench? Rather than, I mean, you're saying we have to read something into this statute, a lesser, and this is a criminal statute, so we're not talking, that wasn't put there at the time by the legislature.
Your Honor, I would not ever recommend to legislate from the bench, instead only interpreting the intent that was made by the legislature and looking at the definitions that are further provided in this statute. And what those definitions say, the definition of knowingly, or even the definition of malicious under the Florida statute 806.13 states, with the knowledge that injury or damage may be caused to another person or the property of a person. These definitions and the intent of the legislature through their amendments clearly show that a knowingly or a higher standard is not what was recommended. Instead, they were recommending a reckless standard. And at least in regards to the statute, that is why we advocate for that standard today. Now, looking back on the true threats doctrine, it is argued that the statute in the first place is unconstitutional due to a violation of the right to freedom of speech under the United States and Florida constitutions. The Supreme Court, however, through cases such as U.S. v. Watts, considers that communications that are classified as true threats are not constitutionally protected.
So how do we know that, first of all, we don't have the actual language that was used, and so how do we know that it was a true threat? What facts are there that indicates that?
Justice Quince, the record is vague on the wording exactly of the communication, but it is clear on page 22, lines 6 through 7, that the lyrics that were posted contained violent imagery that was concerning the victim. And furthermore, the record also shows that it was not just the victim who was impacted by the lyrics, but it was also different friends and family members that saw the post as threatening. So looking to our definition of a true threat, which is defined under U.S. v. As saying that a statement is a true threat when a reasonable speaker would foresee the statement as being...
Are we to interpret whatever was said in those lyrics that he was threatening not only the ex-girlfriend, but others?
Justice Quince, the lyrics, the record is clear that the lyrics were violent imagery that was concerning the victim. If any other victims or persons were involved, that is uncertain. What is certain in the record is that other students and family members thought that the posts were threatening to the victim, and that is what satisfies our definition of a true threat under U.S. v.
Well, it
Costa.
sounds to me like you're saying now you want to use an objective standard, but then you're saying testimony about what other people thought would be relevant, which seems like subjective. So if the defendant brought on 5 of his friends to say, look, I see things like that all the time. I look at rap lyrics. This is just music. This had nothing to do with the victim. So is that kind of testimony appropriate if we're going to be going with an objective test?
Your Honor, we would say so, considering that the record is clear that these students and family members that were used for this objective test were not as closely linked to the victim as you were describing in your hypothetical. And for that reason, we would say that they do satisfy that objective test.
So your opponents argue that the picture of the ex-girlfriend was included in a bunch of other pictures. And so are we to believe that the lyrics were a threat to all of the people that were included in this group of photographs?
Justice Quince, we would not argue so. The communications and the lyrics and the photographs are distinctly separated. The lyrics are, the record is clear that it is directed at the victim. It was. And
the victim's name is actually used in the lyrics to the song?
Whether that is the case or not, Your Honor, is not clear. What is clear is that the lyrics were violent imagery that was concerning the victim. And considering the impact not only on the victim, but the objective characteristics that can be derived from the students and family members, we would argue that that satisfies the objective burden. And as a result, the communication is a true threat, meaning that it is not constitutionally protected. Now, to be sure, the exact definition and burden of a true threat is contested. For example, our friends on the petitioner side argued the case of Virginia v. Black. But it is important to note that concerning true threats, the only thing that the Black case established was saying that true threats encompass statements that were made with the intent to threaten. Whether statements without intent could be true threats was not left to the court in that case.
But aren't there two different issues? One is the intent standard as to what the defendant what the defendant intended to do in sending the communication. So that's either the recklessness that the trial judge instructed on, which isn't in the statute. The second issue is whether in evaluating whether it was a true threat, it's objective or subjective. Do you see those as two different inquiries? That is, what the intent was of the sender and what the whether objectively it looks like a threat or not?
Your Honor, they are distinct in some ways, but to be sure, for it to violate the statute, given the recklessness standard that we advocate for, it would have to be a true threat. As if it was not a true threat, then it could not be constitutional. And
so it sort of goes around in a circle. How do you find,
exactly.
If it's a true threat, then it's not protected, but the issue of whether it's a true threat is a question really of fact and law, isn't it, as far as who determines whether it's a true threat?
We would argue that the facts in this case not only provide for the objective standard through the reasonable persons, but the evidence in this case, specifically through the injunction, would clearly surpass that through a recklessness standard. I see I'm out of time. Chief Justice, if I may briefly conclude.
Just wrap it up.
When considering which interpretation to use for the true threats doctrine, considering that currently 9 federal circuits apply an objective standard, and perhaps most importantly, as you brought up, Justice Pariente, the 11th Circuit does, adapting this objective standard would be adapting to this court's jurisdiction of their Court of Appeals. And considering the statute, because of this injunction that was given to the petitioner. Because he was asked to stop the communications, but he continued anyways, because he was on notice of the impact, at the very least, he was consciously disregarding the damage he was causing. So as a result, he recklessly and maliciously disregarded the damage his communication would cause. The definitions of the statute, the legislative intent, the protection order, they all suggest at the very least that the communication was a true threat that violated the statute. And it is for those reasons that we would ask this court to uphold the decision of the 6th District Court of Appeal. Thank you.
Thank you.
Good afternoon, Chief Justice La Varga, honorable justices, and may it please the court. My name is Jasmine Del Valle, and today I'll be presenting the second issue in this case, and that is whether Florida Statute 784.049, addressing the public dissemination of intimate photos taken by petitioner through social media, violates the right to freedom of speech protected under Article 1, Section 4 of the Florida Constitution and the First Amendment in the U.S. Constitution. Florida Statute 784.049 does not violate the right to freedom of speech protected under these constitutions due to the fact that the intimate photos shared on social media are obscene. Therefore, the statute must be reviewed under a rational basis review.
Wait a second. We're going from photographs. There's nowhere in the jurisprudence of the U.S. Supreme Court that in a situation where there's, whether it's in movies and whether we like it or not, HBO now, where a nude photo of a person's torso would be considered obscene. So are you would be asking us to say as a matter of law, a photograph of a female body who's over the age of consent and is an adult is obscene?
Well, Justice Periante, to answer your question, I would look towards Miller v. California and Roth v. U.S., in which it determines a three-pronged test in order to determine whether an image is obscene, and that is whether in and of itself the nudity in the photo appeals to prurient interest, whether the average person applying contemporary community standards considers those images to be obscene, and whether it has legitimate value.
Do you remember Justice Potter Stewart, about his definition of obscenity?
If you're referring, Justice Periante, to he knows it when he sees it?
Yes.
Well, we would rather apply the three-pronged test to determine...
Here's the problem, though. Here's the problem. I mean, we don't want to, in deciding this case, which, and I know we have it briefed the way it's briefed, look at the big factor that differentiates this is not the obscenity factor, but it's the privacy factor. Is that a person who is on a swimsuit, cover, or in Playboy, or in any of the other, again, lots of movies in this day and age that may be, not PG, certainly above, have nude photos of at least the top part of female bodies. But in no way, under your definition, the Congress could ban all of those movies and books and magazines.
You're absolutely right, Justice Periante. That's why in the plain language of the statute, it states that there must be consent to take the photo and consent to post the photo. There must be intent to cause substantial emotional distress when publishing the photo on the internet for the worldwide to see, and there must be a negative psychological effect on the victim.
So that's different. Then why does your argument have to be hinged on whether the photo is obscene or not?
Well, Justice Periante, my argument, we're not just arguing that these photos are obscene, because we have recognized that some people do not view these images to be obscene. And
I'm not saying, I don't want to get into disagreement. I just think the general society would say we don't like this, and but it is what is now in our culture and has been for some time, whether it objectifies the female body. But these were, as you said, they were taken by consent. So isn't the First Amendment argument more appropriately looked to whether it was taken with consent, but it was not, there was no consent to disseminate it? and that therefore there should be no freedom of expression protection.
Your Honor, we're not trying to limit the expression. We're trying to limit the effect that this type of expression has, the abuse that the petitioner used in this case, the abuse of the freedom of speech that the petitioner used. And so the victim in this case, we do concede that there was consent given to the petitioner to take these photos. However, there is an expectation of privacy when there is an intimate relationship between two people. The best hypothetical I can compare this situation to is the relationship in between a doctor and its patient, or a bank and its client, or a waiter and its customer, where there's information shared between the two. There's consent to release this information. However, there is no consent given to publish this information outside of that particular relationship. And so that is what the state is arguing for today, that we continue this statute in order to prevent the psychological harm that it may have on the victim for this information to exceed the confines of that particular relationship.
But I hear what you said still is that there is, if it's obscenity, then it's a lesser standard. But why can't we look at this and say there is First Amendment protection and it's strict scrutiny, but that this statute furthers a compelling state interest in protecting individuals who do not consent to their photos being placed on the internet from that highly embarrassing and psychologically damaging communication.
You are absolutely correct, Your Honor. And when you say strict scrutiny, that would be if the photos were considered not obscene. And in that case, we would have to prove that there would be a compelling state interest.
Can you
Yes.
prove your case based on that alternative?
Yes, of course. Okay. So the respondent in this case, we have the responsibility to prove a compelling state interest, that this statute is narrowly tailored, and that we enforce this statute in the least intrusive means according to strict scrutiny. Now, the compelling state interest is protecting the psychological well-being of the victims in these cases. Petitioner is arguing that this statute is unconstitutional in its face. However, if this statute were to be deemed unconstitutional, the consequences, the costs would far outweigh the benefits of getting rid of this statute. These types of photos they are regarded as revenge pornography, but the most specific term for this is non-consensual pornography, where nude photos are posted online without the consent of the person depicted in the image. And these photos can destroy the victim's intimate relationships. They can destroy their educational employment opportunities. Victims are routinely threatened with sexual assault, stalked, harassed, fired from jobs, forced to change schools. Some victims have actually committed suicide as a result of the embarrassment and the humiliation and the opportunities that are stripped from them.
Let me ask you this way. You use the hypothetical of someone going to a medical office and giving consent for limited purpose. That's one thing. But here, there's no question that when she was in a relationship with this man, that she consensually allowed these photos to be taken, correct?
Yes.
Why in this day and age, why do people women allow this to be done with their consent? I mean, there's enough, as you say, there's enough out there to know there's a risk that this is going to get posted. I mean, it used to be in the old days, somebody would whisper what happened, and everyone would know then somebody did something that maybe their parents wouldn't approve of. Now, people take photographs or they're sexting, and so I don't get that after somebody is allowed that photograph to be taken, that they have that same interest in our expectation that it's not going to be shown to other people.
Well, Justice Periante, we're not endorsing the behavior of these photographs. We're not endorsing that, okay, you should be able to post nude and expect that these photos are not be posted on the internet. However, there is an expectation. Comparing this case to another hypothetical in regards to law, just because late at night there is a risk of drunk drivers doesn't mean that people don't go out and drive at night if they're not drinking, with the risk of getting hit by a drunk driver. So we're not endorsing this wrongful behavior in the photo. We are trying to criminalize the petitioner in this case and others similar to the petitioner who are posting these photos simply to cause substantial emotional distress to the victim.
If the victim had in fact at some point prior to this sent the photographs to a third party, we would have a different argument here than because under those circumstances, she's obviously given up her expectation of privacy by giving it to someone else, correct?
Yes, Justice Quince, your hypothetical, when applied to this statute, the petitioner would not be able to be convicted under the statute due to the fact that, like you said, the victim in this case would have given consent to a third party to use this image. However, this particular case is when the petitioner took a photo of the victim along with the threatening lyrics that were posted, which goes to the intent to cause substantial emotional distress. And so these were photos taken by the petitioner, posted on his public faceplace page for the world to see. And so that is how it is different from her sending it to a third party. And so
how many times must it occur that photos are published that you would prefer not be published? But how many times does this have to happen in society before it impacts this right of privacy, that it happens so many times and it's becoming a common occurrence? And how does that factor into a discussion with regard to the innocence of this is the first time this has ever happened?
Well, Justice Lewis, this would not be the first time that this has ever happened, and you're right, the expectation of privacy is definitely a main factor of our concern. And so that is why we are asking for the continuance of the statute. If the statute were not to be continued, then this would sort of endorse this type of behavior. This would sort of say you can post...
But it's the reason that the statute is justified is the privacy interest.
Yes.
So if this has become a common occurrence, is that still entitled to that initial protection of privacy so that it does not become circular?
Well, the reason why the state is trying to continue this statute is to protect the right to privacy. We do not argue that the right to privacy is more important than the right to speech. However, like I said before, the petitioner in this case has abused his right to speech to cause substantial emotional distress to the victim. And so that is why we're so interested in not only the victim in this case, but victims in other cases who have been affected by sex traffickers who use compromising images to trap unwilling individuals in the sex trade, as well as rapists who record images of sexual assaults to discourage their victims from reporting it to the police, and also domestic violences who use this as a threat as well. And so unfortunately, we're not saying that females are the only ones who are the victim of these cases. Males and females are affected by this. However, the fact that the majority of females are open to the worst victimization, we are arguing that the discontinuation of the statute was sort of also undermined the gender equality when it comes to protecting...
Well, you're out of time, but you're really now going to way beyond, because what you're saying is a broad statute that may convict the innocent is okay because it could be harm occurred, whereas what I hear they are saying is it hasn't been narrowly tailored, and that it's therefore the state needs to redraw it. So when you raise sex trafficking, and what we're talking about here is somebody who consented to have her picture taken by a boyfriend, we're talking about two different situations, and yet this statute seems to cover both, and isn't that the problem?
Chief Justice Labarga, I see my time has run out. May I answer a question and briefly
answer?
Yes. Well, the state argues that the statute is in fact narrowly tailored, in which it defines that you must have consent to take the picture, you must have consent to post the picture, there must be intent to cause substantial emotional distress, it must have significant psychological harm on the victim, it must be on an internet website for the worldwide to see, it must be posted through a computer or a storage device, and it must identify the person. And so all of the languages and the fact that sexually explicit and sexually cyber harass, the image, personal identification information, all of these terms are defined in the statute. And so it makes it not very likely, if anything, not likely at all, to criminalize inadvertent posting where it requires an intent to cause substantial emotional distress. And the intent in this case was disregarding the protection order that the victim issued against the petitioner in this case, in which he knew this was causing significant psychological harm, and he consciously disregarded this to cause substantial emotional distress. And so it is for these reasons that we, the state, ask for an affirmation for the lower court's decision and consider the statute constitutional.
Thank you.
May it please the court. I would like to address 4 issues with regards to my friend's argument. The first is I would like to answer your question, Justice Pariente, and that this court could reverse the decision of the 6th District Court of Appeal on plain error grounds, and that there was an inappropriate instruction to the jury for recklessness when the statute clearly requires a mens rea higher than recklessness. Furthermore, we would argue that an objective test that was used in the lower court impermissibly chills speech because it runs the risks of punishing crudely worded ideas. And as Justice Harlan said in Cohan versus California, one man's vulgarity is another's lyric.
Doing what? I'm sorry, I didn't hear you.
It runs the risk of criminalizing crudely worded ideas. And we believe that a subjective test would be a better demarcation between ideas and true threats. With regards to the second issue.
Your argument is that the change in the lyrics and with the posting of the pictures was a crudely worded idea.
Yes, Your Honor. These lyrics were posted for a therapeutic purpose because petitioner, Mr. Bartram, had just gotten over his relationship and he was trying to help himself with this relationship.
Doing therapy for himself by threatening someone else.
Your Honor, we argue that the statements that were made in this case were not intended to threaten the other party. These statements were posted on his Facebook page.
So why didn't he just write a letter like most therapists require that they do, and write it and keep it to himself?
Your Honor, we believe that the means the petitioner chose does not necessarily show that he had the subjective intent to place the victim in fear of bodily harm or injury. We merely argue that because he did not direct it at the victim in any way, he did not tag the victim in this case, he did not post these lyrics on the victim's page, and he did not send them.
He posted them so that others, I mean, clearly anyone else who had a Facebook and could tap into that, and certainly those who were friends on his Facebook page, correct?
Yes, Justice Quince, that is true. However, those people would voluntarily visit his page and see those lyrics. And if I see that my time has expired, may I briefly conclude?
Sure.
We would ask this court to follow the guidance of Justice Brennan and Texas versus Johnson. If there's an underlying principle, a bedrock principle to the First Amendment, is that the government may not prohibit the expression of an idea simply because society finds that idea itself offensive or disagreeable. We ask that this court reverse the decision of the 6th District Court of Appeal.
Thank you for your arguments. What we're going to do is we will retire back to our conference room to make our decision. I would ask that the person in charge of this proceedings, if you would accompany the marshal, because we have a couple of questions for you. Thank you.
All rise.